Hi everyone, my name is Brianne and I'll be coordinating the Wills program this year. The Wills Project is one of about 20 programs offered through Pro Bono Students Canada at our law school. The Wills Project aims to offer free wills and power of attorneys to those who need them while also giving incredible legal experience to our students. Clients who wish to participate will work with students supervised by lawyers at Stewart McKelvey here in Fredericton to produce these documents free of charge. All that is required is that the client have less than $65,000 in global assets, excluding a home, and no more than $35,000 in annual income. You can reach us at the email listed at the end of this presentation, which is willsproject@unb.ca. Today, we aim to give you a better understanding of why wills and power of attorneys are such vital legal documents. Please don't hesitate to contact us with any questions. Okay, so before we start, I just want to do a quick note on legal information versus legal advice. So, as law students, we are only allowed to provide legal information and not legal advice. So this distinction is really critical for us. So legal information is just general information about the state of the law in whatever area you're talking about. So things like legal definitions and procedural steps, how to find the legislation or cases that are relevant. So all those things our students can do. Legal advice is more interpreting how the law applies to your specific situation or a specific situation. And that includes things like making recommendations on the procedure, reviewing the law relevant to a particular set of facts or a specific situation, and applying it to those facts. So in those cases, we have our supervising lawyers from Stewart McKelvey, and so our students might have to step out and get a lawyer or maybe get back to the client because we're not actually able to provide that information.
Hello everyone, my name is Cassia Curley and I'm a third-year law student at the University of New Brunswick, and I'll be working on the Wills project this year. So what is a will? A will is basically a legal document that allows a person to provide instructions on how to distribute their property after their death. So what can a will do for you? So a will can offer you and your loved ones a peace of mind. However, it's a difficult step, but a will can enable you to name the people that you wish to receive your assets after your death. So first, let's cover some basic terminology associated with the creation of a will. So a will is a legal document, and the person making the will is called the testator. So any assets that you own at the time of your death are collectively called your estate. Assets can be real estate, money, investments, or other personal effects. The beneficiaries are the people or organizations that you wish to receive your assets after your death. In your will, you will name one or more executor. This is an individual who is responsible for carrying out your wishes and distributing your estate. An executor can be a person or a trust company. We will discuss some general guidelines for choosing an executor later in the presentation. So, the guardian is the person named in a will who cares for a child. The probate is a legal process that a will is used to be proved in court. This will be accepted as a valid and true will of the testator. So what happens when you don't have a will? If you die without a will, you are said to die intestate. There is legislation called Devolution of Estates Act that will come into effect and sets out who will receive your estate and what portion they will receive. When you die intestate, your estate will be divided into fixed shares among people the law regards as your next of kin. This basically means that money could go to distant cousins you've never met when you'd prefer to go to friends or neighbors who you have a more considerable history with. Your estate will be distributed not by someone you have selected, but by a court-appointed administrator. So, some benefits of having a will. Having a will is basically a good idea for several reasons. A will allow you to distribute your property as you wish to the people that you choose. A will allows you to choose your own executor. Again, this is an important consideration because they will actually be responsible for distributing your estate, and you want to make sure that they are responsible and dependable. A will gives you more flexibility. It allows you to use trusts and various legal methods to help manage the benefits provided to your survivors. It also allows you to give your executor the appropriate power to carry out your wishes. A will also allows delays and costs in court. It should also save time and money by eliminating the need to make an application to the court to have an administrator appointed. It also allows for flexibility. As we will address later in more detail, lawyers can help identify different ways to deal with your property and have your wishes fulfilled. Not all of it has to pass through a will, and sometimes it will be beneficial and more cost-effective to have it dealt with in other ways. However, you may be required by law to provide for your dependents, such as your spouse, dependent children, or common law partner. One of the most important things for many people in creating a will, even at a young age, is ensuring that you are able to choose the appropriate guardian for any minor children.
Hi, my name is Ian, and I'm in my third year of law at UNB Law. I will be part of the Wills Project this year. I will speak to you about some responsibilities after death. The law requires that an individual care for their dependents, a spouse or partner, and children. If your will does not adequately provide for them, the court may override or change it. For example, the court could give order that your estate provide for your dependents or give your spouse a proper share of the marital property. The extent of these obligations is something that your lawyer can help you with, since it could potentially bring several pieces of legislation into play, for example, the Marital Property Act. Next, I will speak about some costs paid by your estate upon your death. People sometimes forget that they can only give away what they own at the time of their death. Your debts do not just go away when you die. The first thing that your estate must do is to pay for your funeral if you have not made arrangements in advance. Then your debts must be paid off. If you own investments, these are deemed to have been sold at the time of your death, with the result that there may be a capital gains tax owing. Finally, there will be the cost of administering your estate. Your beneficiaries will only get what is left over. When making a will, it is a good idea to get advice from a lawyer. It is possible to create your own will in handwriting or to complete a will form. This is risky business since your will must be properly made and executed or it will not have legal effect. Plenty of examples where courts did not give legal effect to printed wills, despite the intentions of the testator. There are greater risks, however, if not having any will. If you're going to do a handwritten will, it is best to use a will form and carefully read the instructions. There are rules that accompany the signing of a will. If you don't properly execute the will form, this can cause considerable expense and heartache to your intended beneficiaries. You must have 2 witnesses, and they both have to be present at the time to see you sign the will. A witness to a will cannot be a beneficiary of the will. Next, I will discuss some tips for preparing a will. One tip is hiring a lawyer to prepare your will. Your lawyer knows how to prepare a will, and he or she will make sure it's properly prepared and properly signed. The cost can be $300 to $1,000 depending on the lawyer and how detailed your will is. From a lawyer, you will get advice on how to deal with things like jointly owned property or insurance proceeds. A lawyer will be able to tell you your legal obligations and provide advice about estate planning. Your lawyer can also help you set the order of priorities among your bequests, or will suggest giving the beneficiaries a percentage so that an increase or decrease in the size of your estate will not alter the balance between your various beneficiaries. Your lawyer will prepare a draft of the will. He or she will review it in detail with you. If there is any part that is unclear, be sure to ask for explanation. After it has been reviewed, it can be signed and witnessed. Some information that you will need when you create your will is whether a lawyer assists you or whether you write your will on your own. You should gather together the following information: full names and addresses of the beneficiaries, including the details of your children's age and special needs. If you want to leave something to an organization, such as a charity, find out the full legal name of that organization. Detailed list of all property, including pensions, insurance, and annuity contracts. You should also list your debts and the location of your bank account and other assets, even if you are not sure that these will be covered by your will. Copies of any marriage certificates, details concerning your place of marriage, plus any domestic contracts, prenuptial or separation agreements. Some other information that you will also need are a copy of your previous will, if you have one, general instructions on how you want to divide your property, names and addresses of those you want to appoint as your executor, trustee, and guardian for your children. Be sure to provide for an alternate in case your executor can't act for some reason.
Hi, my name is Alden, and I am a second-year student at UNB Law, and I am also working on the Wills project this year. First, we will be talking about choosing an executor. Choosing an executor is an important part of preparing your will. Your executor should be a person who is suited to settling your affairs after you are gone. When a will is uncomplicated and the beneficiaries are family members, many people do ask a family member to act as executor. Some people will ask a trusted friend or business associate to act. In some cases, you may choose to appoint more than one executor. For example, you might have a family member act jointly with a professional. If you do not have someone to act as an executor, you can hire a trust company. Some of the things to consider when you choose an executor include: you want to choose someone you can trust. Someone who is willing and able to take on the commitment of handling your affairs. The person you name in your will is not obligated to take on the role, so it is important that you discuss this with the proposed executor ahead of time. It is important that the person be accessible to handle your affairs. Your executor must be at least 19 years old to be recognized by the courts as your executor. The complexity of your estate. If your estate is large or complicated, you may want to find somebody with the appropriate qualifications to act as your executor. Ask your lawyer about what specialized advice your executor will need, such as the advice of a lawyer, an accountant, or an investment advisor. You may want to appoint a professional, although your executor can obtain professional advice and assistance. See PLEISNB's pamphlet, Choosing an Executor, for more information. Next, we will talk about the executor's role. Your executor acts as a trustee over your estate and distributes it to the various people and organizations you have named in the will. The executor takes his or her authority from your will and is also governed by law. The duties of an executor range from tasks as simple as making an inventory of your assets and selling your house to more complex tasks such as distributing stocks and completing income tax forms. The executor may hire an expert when it is necessary. There is a bit of paperwork involved. You can select an individual or a trust company or a combination of both as your executors. People often wonder if they have to pay their executors a fee. Family members may agree to administer the estate without taking a fee. However, your executor has the right to be paid for his or her services. If you do not provide payment in your will, your executor can apply to the probate court for a reasonable fee. Because someone can apply for a fee, if you think your executor will expect a fee, you may want to set an amount or a maximum limit on how much your executor may take. If you have more than one executor, they have to share the fees, whether they are set by the court or stipulated in your will. Fees received by executors are taxable in their hands. If you appoint professionals as your executor, such as lawyers or accountants or a trust company, they will be expected to be paid for their services. You should work out in advance whether you must pay the professional executor an executor's fee instead of that professional's ordinary charges or in addition to such charges. Here are a few things to remember when thinking about signing your will. Do not leave your instructions for your funeral in your will without leaving separate instructions in a letter to your executor as well. The will may be read too late. Have the people you named as executor, trustee, or guardian agree to accept your appointment. They are not obligated to assume these roles. Discuss your plans with them to be sure they are willing and able to act. Do not try to make changes on your original will yourself. They may not be effective. Review your will with your lawyer every few years. You must have 2 witnesses to your will. Neither of the witnesses nor their spouses can be beneficiaries of your will. If you use a lawyer, he or she will normally supply the witnesses. You must be mentally competent to make a will. This is an important issue for older testators because once a person loses mental capacity, it is not possible to give instructions. Revoking or changing a will. A will can be changed or revoked at any time as long as you are mentally competent to do so. In order to change or revoke your will, the best idea is to contact your lawyer. Reasons for changing a will include such things as a change in your marital status or family status, such as the death of a spouse, a divorce, separation, remarriage, or the birth of a child. Remember, some events like remarriage can affect your will, while certain changes would not affect your will even though your intentions may have changed. For example, a separated or former spouse who is named as a beneficiary in your will would still inherit no matter how long you had been apart. The death of your executor or beneficiaries, changes in tax laws, changes in your financial status. A large gain or loss of money could cause you to realign priorities. Changes in the health status or status of a dependent. You may want to establish a trust to look after an ailing dependent. Departure from the province of a guardian, trustee, or executor. You must formally change your will if that is your intention. Ask your lawyer to send you a reminder to have your will reviewed every 3 to 5 years. Next, we will be discussing the powers of attorney. Powers of attorney, or POA. A power of attorney is a written document where a person, often referred to as the donor, gives another person or persons, called the donee, the authority to act on his or her behalf in relation to property, financial affairs, and/or personal care. For more information on the powers of attorney, please see the PLEISMB's pamphlet entitled Powers of Attorney. Are there different types of powers of attorney? There are 2 different types of powers of attorney. First, powers of attorney for financial and property matters, and secondly, power of attorneys for personal care. Each type of attorney is governed in New Brunswick by different acts and is for a different purpose. Powers of attorney generally. You can have one power of attorney that covers both healthcare decisions and financial decisions, or you can have 2 separate powers of attorney. If you have 2, you can appoint the same person for each power of attorney or different people for each. Even if you have an enduring power of attorney for financial matters, if it does not include provisions for personal care or you do not have a separate power of attorney for this purpose, your donee would not have the authority to make your personal care decisions. Any mentally competent person over the age of 19 can give a power of attorney. Anyone who is mentally competent and meets the legal requirements. A power of attorney can be an important part of your planning if you become unable to manage your financial or personal affairs because of physical disability or mental incompetence. It is important to plan ahead. If you delay in giving the power, you may be unable to do so when you need it. Powers of attorney generally. A power of attorney gives the donee a lot of power in managing their affairs and can stand in and act as you. So it's important that you choose someone that you trust. Like an executor, being a power of attorney is a voluntary role. You want to select a donee that is reliable and trustworthy. The donee must carry out their duties according to your instructions. If there are no instructions, then the donee must manage your financial affairs and personal care in your best interest. In carrying out the duties, the donee must act reasonably and in good faith for your benefit. As long as you are mentally competent, you can revoke your power of attorney and name somebody else. This means that your power of attorney is not set in stone and you are able to revoke it at any time.
Hello, my name is Jonathan Adams. I am a second-year student at the University of New Brunswick Faculty of Law and also a member of the Pro Bono WillsProject this year. I'm going to be talking to you about power of attorney for personal care and for financial matters. So, the principal, or the person who's assigning power of attorney, you in this case, are able to create power of attorney for particular purposes and for particular time periods. For instance, if you leave the country, you can nominate someone to take care of your legal or financial obligations in your absence. Or if you're having a prolonged hospital stay, then you can nominate someone to act on your behalf. The type of power of attorney you choose will depend on your circumstances, so it's important that you consult an attorney or an expert in advance. But these types might include revocable power of attorney, irrevocable power of attorney, and enduring or durable power of attorney. In general, power of attorney will expire once the principal is no longer competent. In order for your power of attorney to remain effective, once they become incapacitated, they must create enduring power of attorney. This is typically what people envision when you mention power of attorney. Enduring power of attorney will only be nullified upon death rather than upon incapacity. People should be aware that if they become incapacitated while the enduring power of attorney is effective, it becomes much more difficult to remove that person. So always exercise care and attention when you're nominating that individual. To create enduring power of attorney, it's as simple as adding a clause on the document of power of attorney. And this document must be signed in front of a witness, someone who is not the donee, the person who is receiving that power. You can create power of attorney for a particular purpose, such as power of attorney for personal care. This person will make decisions on your behalf, like what care facility you'll live in, or what course of treatment to pursue upon doctor's orders. In the case of power of attorney for personal care, the donee would be making decisions about your health care, consent to medical treatment, nutrition, shelter, even down to what clothing you wear and matters related to your personal safety. And because of the fundamental importance of these decisions to your happiness and health, the power of attorney is under a legal obligation to always act in your best interests. Your power of attorney for medical care would assume their role actively upon your incapacity or mental incompetence. This would be judged by an examining doctor who would attest to capacity or lack thereof. Once that incapacity is judged, the power of attorney would be actively starting to make medical decisions for you.
Hello everyone, my name is Katie O'Keefe and I am a second year student here at UNB Law. I will also be working on the Wills Project this year. I'm here today to talk to you about some power of attorney tips. If you do not have a power of attorney, without a power of attorney for personal care and/or an enduring power of attorney for financial matters, someone may have to apply to the court to become your legal guardian. By planning ahead, you can help your family avoid the time, cost, and stress that a court process could create. A few things that you should know. Sometimes people are afraid their donee might abuse the power of attorney. If you have this fear, discuss it with your lawyer. Consider appointing 2 or more donees who must act jointly. See PLEISNB's booklet, Protect Yourself from Abuse and Fraud, a guide for seniors. The Pro Bono Students Canada Wills Project. Thank you, Public Legal Education and Information Service of New Brunswick, PLEISNB. This presentation would not be possible without their help and material.
Okay, so with that, I'm just going to recap a couple of things about our project, and that'll be it for us today. So the Wills Project is a joint effort, like I said, between qualified legal professionals. So in this case, Stewart McKelvey here in Fredericton helps us out, and the law students. So we have 2nd and 3rd year law students this year to create opportunities for greater access to these important legal tools. The goal of this project is really to help those that are in need of these documents to get them in a way that's inexpensive but still just as effective. So like I said at the beginning, in terms of who qualifies to participate in the Wills Project, there's generally an annual income of $35,000 or less, and less than $65,000 in global assets, excluding a home. I would encourage you, even if you think you might kind of go above these caps, just to get in contact with me anyway, and we can kind of see where we're at and what we can do for you. So like I said, if you think for any reason that you qualify for this program and you don't already have these documents, please don't hesitate to shoot me an email at the email listed on the screen here, willsproject@unb.ca, and we'll do our very best to accommodate you. So I know this presentation was a little bit different than probably what all of us are used to, definitely a little bit different than the ones I've given for this project in the past, but hopefully this was helpful. And because there really isn't any way to answer questions live, please feel free to send questions to the email on the previous slide as well, and I'll do my best to get you answers. Thanks everyone, bye.